and I am delighted to see you all joining us for another exciting webinar. Oh God, you focused on me. That's a frightening thought. As you know, we've got some amazing speakers today. So we've got Anne Russo, the Executive Director of the Dispute Resolution Board Foundation. And no, oh, you can stay on that one, Cameron. Okay. And Giorgiana Tecuci, who acts as the Director representing Europe on the DRBF Region 2 Board of Directors, and is also a lawyer of international repute in her own right. As you know, David Sears QC was going to be talking today, but obviously that isn't possible. And so with huge apologies to David, you've got me instead. The brief format for today is Anne is going to introduce the DRBF, and then I will speak relatively briefly about adjudication before handing over to Giorgiana to talk about some of her top tips in the use of dispute boards, and also to straighten out any misconceptions about dispute boards, what they are and their uses. And then there'll obviously be time for questions. So some quick housekeeping. Obviously this is Zoom, it is a webinar, but we use the meeting function so that this means everyone can see your picture and your name. You may or may not know that you can go in and edit your name on your photo. So you can put your name, you can always put the country you're from. But one of the things we want from this is we want you to be able to network with other people on this webinar. It helps to remind all of us that there's other people out there, and it, I think, encourages a more positive approach. So your video and audio transmissions are turned on, but once we get going properly, if you can just make sure you're muted, that would be great. Please do use the chat function. So if in the chat function you can put where you're from, if you want to give more information, you can put your place of birth, but I mean where you're from today, where you're joining us from, city and country. Just the city, I'll know the country. If there's somebody you'd like to talk to, do send me a message in the chat and I'll link you up afterwards or during. Can you also put in, it's always really useful, and I know those of you who have attended before, you might be bored senseless by this, but if you can put which form of contract you use most, can you also, because of today being dispute boards, can you also put in whether you've used a dispute board? And has that been, you've used it as a client, you've used it as an advisor, or have you sat on a dispute board? It would be really useful to have that information. As I say, these webinars are intended to be more than just a learning process. The aim behind them is, I think it's to help everyone network, to share experience, and to, you know, genuinely to collaborate. So please do give us some feedback, both in the chat, and you'll get an email afterwards. Be very interested to hear about things you would like future webinars to be about, subjects, and if you'd like to speak at one of them, please put yourself forward. Also, if you'd like to write an article for our institutional newsletter. Just in case you didn't know, I am Bill Barton. I'm one of the directors here at Barton Legal. My specialty is construction and engineering. So as host of the webinar, it's my job to make sure that everything runs smoothly. So if you do get any problems, say, and of course I'll just ask someone else to fix it. If there's something wrong with your screen or whatever, Cameron is on hand. So if you just put in the chat, Cameron help, he'll sort it out. So before I come on to introduce Anne and Giorgiana, I would like to say a few words about David Sears. Due respect to other people on this call, he was one of the most wonderful counsel I've ever had the privilege to know and instruct. I knew David for probably 30 years, and he was a very good friend, as well as someone I always turn to for help and advice. And I know there's a lot of people on this call and elsewhere who are far more eloquent and intelligent than I am to tell you of the real brilliance of his advice and sharp mind. Unfortunately, knowing him for so long, I rudely took all of that for granted and just presumed that he would always be here to advise and guide me. And that there wasn't a selfish bone in David's body, but I mean, I do think it's being incredibly selfish to go and die and leave us at this point in time to find another counsel and a friend. It is really inconvenient. But my advice to all of you is that if you have someone that you really trust, that you do rely on in times of trouble for advice, or to listen to as a sounding board, make sure they know that and don't wait until you're in need before you tell them. I was luckily instructing David just in a week before his passing, so he knew that I was still taking the piss out of him then, so that was fine. But for anyone else, don't wait. Tell people how much you care and go and speak to them. Moving on, I'd like to introduce our first speaker, Anne Russo, who, as I mentioned, is the Executive Director of the Dispute Resolution Board Foundation, and which, for those of you who don't know, and you're here to learn more about the DRBF, is a non-profit association dedicated to the use of dispute review boards around the world. Anne has been a key figure in DRBF since 2002, performing in a number of leadership and administrative roles, as well as receiving the President's Distinguished Service Award in 2005. She was DRBF General Manager from October 2013 to December 15, and Executive Director since January 16, which means she has a vast level of experience, particularly in relation to association management in construction and dispute industry. She's also co-author of the Dispute Board Manual, a guide to best practice and procedures, and she's editor of the DRBF's quarterly journal, The Forum. Then, of course, the second speaker is Giorgiana Tecuci, and I know that you'd be even more impressed if I could ever pronounce your name correctly, and can only apologise again. I've had very concentrated lessons from one of my sons who's very good at language, and he's still incapable of teaching me how to pronounce your name, Giorgiana, so I can just grovelingly apologise again. But Giorgiana is a lawyer specialising in construction law, and here's a list of her achievements, which are a multitude. She has a master's degree in European and international law. She's a chartered arbitrator and adjudicator. She's a certified trainer. She's a certified project manager and a FIDIC accredited trainer. Moreover, she's represented FIDIC in Romania for a number of years and is a member of the FIDIC Capacity Building Committee and coordinator of the FIDIC Central and Eastern European Countries Group. There's a mouthful. This, along with being the co-author of 2 special FIDIC accredited modules for the use of FIDIC forms of contracts, show her extensive expertise both in FIDIC and in adjudication. She's a highly respected source when it comes to offering practical experience and advice and guidance on adaptation of FIDIC in Central and Eastern European region, as well as dealing with bespoke standardized forms. And then there's still more. In 2018, Giorgiana was appointed Romanian rep for the DRBF. It sounds like it's like an award party. Lots of sort of gold medals. Resolution, and so she currently acts as a director representing Europe for the Region 2 Board of Directors of the DRBF. So that puts me in my place, because my list of achievements, I think, is probably about one line. Anyway, we're very lucky. So Anne is going to start off, and I believe that Giorgiana is going to, oh, have you got slides, Anne?
I don't. I was just going to make some opening remarks, and then we'll go to your slide deck when it's your turn. All right.
Yeah, over to you.
Very good. Thank you so much, Bill. So it's a pleasure to be here to talk about adjudication and dispute boards with 2 very experienced practitioners, Bill and Giorgiana. One of the highlights of my time at the DRBF has been the publication of the Dispute Board Manual, which Bill mentioned. And this book came out at the end of 2019. Now, Bill and his team are going to share a link to a free download of the book. So you all will be able to access that. It's also available for purchase through any online retailer or bookstore. But the guide does provide the context for dispute boards within the alternative dispute resolution continuum. And today's discussion is going to touch on both adjudication and dispute boards and how they both deliver lower costs, expedient outcomes, and more control by the parties compared to other forms of ADR, such as mediation, arbitration, and the dreaded litigation. So first, I just want to give an overview of how we're defining the two processes for our discussion today. So from our perspective, expert determination and adjudication are very close. They utilize an independent third party to make a quick decision on the issues in dispute. Now, I understand from Bill that in England, expert determination is usually an expert chosen by the parties with binding decisions not subject to court review, whereas adjudication is a tribunal that's appointed by an independent body with enforceable but not binding decisions. This gives the parties little flexibility to adjust the process, and they do not have the opportunity to choose the tribunal or have early involvement of the neutrals. Dispute boards, on the other hand, typically feature a three-party panel of independent neutrals who follow the project from the beginning, resolving disputes at the lowest level through dispute avoidance techniques and advisory opinions. And they generally offer either non-binding recommendations or a binding decision after a hearing. The two processes do have some differences. So adjudicators have no role in dispute prevention, as they are appointed only to deal with formal disputes. They do not follow the project from the start, so they don't know the underlying facts leading up to the dispute. They can be more adversarial with higher costs for consultants and lawyers. And it's not a collaborative process, so relationships can be strained during the dispute resolution process. There are also some similarities between adjudication and dispute boards. They both feature independent neutrals who have expertise in the subject matter of the dispute, which I think is a crucial component. And both processes are expeditious, which is an asset to the overall project delivery and the parties in dispute. So today we're going to start with some pros and cons of adjudication and best practice tips for effective use from Bill. And then he'll hand it over to Giorgiana to talk about some of the common misperceptions about dispute boards and how those can be avoided for maximum results. As Bill noted, we are allowing some time for Q&A at the end. So we'd be happy to see you include questions in the chat or put your hand up at the end so that we can address those questions as we wrap up the session today. So now I'm going to hand it over to Bill to get us kicked off on the overview of adjudication.
Thanks very much. Yep, so you get more of me, so apologies. Right, so first of all, I'm going to deal with some pros and cons. Yeah, so stay on that slide for now, thanks. Pros and cons. I'd say the biggest pro is undoubtedly time. It's a much quicker process. And I'm presuming that, well, I shouldn't presume, that those of you who from the UK will understand adjudication. So I should just backtrack slightly. Adjudication in England and Wales is a statutory process. It is an alternative dispute process. It's now into all non-domestic contracts, and there are statutory provisions that govern timescales and procedure. And I'm quite happy to go into more of those, but that's not really the purpose, particularly of today. But if you want any more information, we do have some guides, and I'm quite happy to send them out to anybody. So just put a note in the chat, that you'd like one emailed to you, and it gives you the whole kit and caboodle. So this is just an overview. So undoubtedly, it's a much quicker process. It's a 35-day process, but one of the cons, there's no cost recovery. So you can incur costs easily of £15,000, £20,000 and a lot more, and you do not have the ability, if you win, to recover your costs. You have to bear in mind that in England and Wales, there is a public policy whereby nobody gets 100% of their costs. And even on, so the highest you'll get is 85%. Indemnity, you're meant to get a higher level, but that isn't the reality. One of the second biggest cons against it, as touched on by Anne, is that it's the process. Adjudicators are meant to be in control of the process, but we all know that submissions in adjudication, there's more of them, they're getting longer and more complex. And you have to compare the process, say, with judges. If a judge says you will do this and you won't do something else, we'll listen. If an adjudicator does it, well, you know, unfortunately, we probably don't listen as much as we should. So timetable is a pro and a con. It's a short process, but the timetable, the adjudicators rarely have the control they think they have. Flexibility, again, it's a con because it's a fairly fixed process. But if you get to come onto this, if you can work with the other side, last year we ran an adjudication over 6 months because we agreed with the other side that we wanted it to be full and final, and so we changed the process. So there is that flexibility. There's nothing certain in adjudication. One of the easiest adjudications is if you miss what is called a pay less notice, but even then there's always a twist. So my advice is, if you're acting for a party, you need to find what that twist or crinkle is before the other side. Another con and a pro is the quality of adjudicators. Some are very good, some in my view are not so good. Let's leave it at that. There's an increase in jurisdictional challenges. So rather than dealing with the substance of the dispute, we now have lots of discussion and argument about, was the adjudicator appointed correctly? Is this the right form under the contract? Is the notice correct? And I'm going to deal with some of those in the cases I'm coming on to. A serious problem with it is there's no early involvement as you get with dispute boards. You can only refer one dispute at a time to adjudication. And so you tend to get an adjudicator, and just because you have another dispute doesn't mean to say you'll get the same adjudicator. And depending on which side of the fence you were on, you might not want the same adjudicator. As to best practice tips, I can say preparation, because you can choose when you start. If you do not prepare, or if the person advising you doesn't tell you to prepare, my advice is bluntly change advisor. You need to prepare in absolute detail because the process is a 35-day process and you will be busy. You need to organize your documentation. You need to have that so that you know where everything is, you can access it, it's in different bundles or sets. In terms of the submissions, I would avoid repetition in submissions. I would avoid the multiplicity of witness statements where, 10 witnesses say the same thing. Adjudicators are bright people, they get it, and actually treating them as idiots isn't likely to do you much good. Make sure that your witnesses can provide the level of detail required. There's lots of instances where you get a witness, they tell you they can provide you with information, and once you start drilling down, they can remember something that happened in a month, but they can't remember or don't have notes about what happened on each day. Again, don't start until you're 100% ready. You need to have everything ready, check it, interrogate what you're doing, and then always expect the unexpected, because in my experience, that is the way to go. Make sure your clients realize just how full on the process is and time consuming. You really have to prep, and they're going to be busy for a month. Choose your experts carefully. It's not just about skill and knowledge of experts. I believe that you need experts who can gel and get on with each other and with you and your client. A team will produce much better results than just having an expert that doesn't get on. It's also not a battle. I know this is how a lot of people want to deal with it. I would encourage you to engage with the party on the other side, because there is a process, and if you can agree that process and be civil and professional, it will run more efficiently. As I said, adjudication is rarely straightforward, so find the twist or the crinkle before the other side does, work out the impact on you and on your client, and deal with it in advance. Again, my advice to clients is present your best case, but also present your worst case. There's no point hiding something. It's going to come out. Bring it up, address it, and explain it in a very clear and balanced way. Can I have the next slide, please, Cameron? Okay, as you know, I'm sorry, but I hate lots of words on slides. So all of these is working out what the message is, and some are more obscure than others, so apologies. So Aqua Leisure, and I should say, there's a very detailed handout that you'll get after this that's about 20 pages. It's got all of the cases I'm referring to and about 10 or 12 others in a lot more detail. I am sprinting through them to just try and give you some of the cases that I think are of interest and ones that it's just worth knowing about. So Aqua, so the parties reached an agreement during the meeting, the exchange of emails and correspondence, but it was all on a without prejudice basis and subject to contract. So the court then held that the settlement covering the adjudicator's decision had been entered into on a without prejudice basis. And so it didn't amount to an agreement that could then be enforced by adjudication. So the case is a reminder that when negotiating an agreement on a without prejudice and subject to contract basis, parties are still exposed to commercial risk. And if you don't make it an open and binding agreement, reduced to writing and signed, then just as here, you may end up with egg on your face. So you shouldn't try and rely on a contract by simply assuming that it exists. Okay, next slide, please, Cameron. Next one, RGB. So I'll do it the other way around this time because you're probably a bit lost. This is a scene from the film They Live, where the main character, Nada, puts on his sunglasses and sees signs that say conform and obey. So this case was about a subcontractor was refused payment as it failed to issue the payment application to a specific email address that was listed in the terms of the subcontract. The court was asked to determine on the validity of that application, and the court found that the payment application was issued late, it didn't value the works to the appropriate dates, it wasn't sent to the correct email address, and as a result, it failed to comply with the terms of the subcontract because it lacked clarity and was ambiguous. So this is a reminder that the payment notices and your applications and the form and content of them are central to the regime set out under the Act. And that whilst I query, in this case, there are a number of defects within the application, as I've mentioned. What would have happened if they'd merely sent it to the wrong email address, but all of the rest of the application was correct? I think it probably wouldn't have been thrown out, but it's about form and content, and it's important that you provide valid notices. I always say to clients, check your contract. Next one. The next slide, Cameron. Right, Hart Investments. So this case is helpful in determining the rigid approach that courts take in the timing for adjudications. As I said, it's a short process and it's governed by the Act. And under that, it requires a referral to be served not more than 7 days after the notice of adjudication. And the inimitable Judge Peter Coulson, QC as he was then, he's now Court of Appeal, held that the adjudication was supposed to be an efficient process and required a strict timetable. He commented that allowing leeway might mean that the spirit of adjudication was lost, and therefore the notice was held to be invalid because it was served on day 8, and therefore the adjudicator didn't have the necessary jurisdiction, and therefore the adjudication decision couldn't be enforced. And so, to explain the film, this is from the Adjustment Bureau, where Matt Damon's character is late for work and finds his colleagues are being manipulated. And the moral and story from this is, don't be late. Next one, please, Cameron. Next is Surrey and Sussex. I had no idea what this picture meant, so I'll tell you at the end. So Part 8 proceedings were issued, so that's a separate court process whereby you use to either enforce a decision or to effectively say that that decision shouldn't be applied. So these proceedings were issued to say that the interim payment notice was invalid, as the email in which it was contained didn't name it as an interim notice. But the court found that although the email did not specifically refer to the notice, it was clear and included sufficient detail indicating the intention. And Mr. Nissen QC held that it was not necessary for a payless notice to have the title of payless notice. Instead, the question is whether viewed objectively, it has the requisite intention to fulfill that function. And of course, you should look at that in comparison with RGB plastering. And the purpose of this film is this Gone Girl, where the main character, Amy, puts on a disguise to hide her identity, but it still doesn't actually disguise who she is, and people were suspicious. The point is, if it quacks, then it's a duck. So if something looks and behaves like a payless notice, in my view, it will still be construed as a payless notice. But don't put yourself in that position. Make sure that you put payless notice. Make sure you refer to the contract. Put the detail in there. Again, it's very easy to do. If you're not sure, seek advice. Next slide, please. Next is just looking at checking time. So Rattigan. So this was a summary judgment application to resist enforcement of a decision on the basis that the adjudicator had breached natural justice by failing to consider a key statement within the adjudication. The court held that the failure to consider the key statement only amounted to an error and not a breach of natural justice. The court said that in order to amount to a breach of natural justice, the breach must be material to the outcome of the adjudication, so much that it would be unfair to enforce the decision. So a question of degree. And as of course you'll know, this is Terminator, and this is where he's injured himself, but as you can see at this point, the injury is only minor, and so it doesn't affect his overall functionality. So the point is here that if there's an error by an adjudicator, but it's inconsequential to the actual outcome, then that is not going to be sufficient ground for you to avoid the impact of the decision. Next slide, please. Fraserburgh. Fraserburgh employed McLaughlin under an NEC contract, and there was a very substantial claim valued at over £7 million. The contractor disagreed that the dispute could be referred to the court because they argued, it was referred to formal proceedings, but the contractor said it had to first be dealt with by adjudication. So it's a very unusual case. And under the option provision in NEC, it states a party does not refer any dispute under or in connection with this contract to the tribunal unless it has first been decided by the adjudicator. And the court basically held that that process had to be followed, and therefore it had to be referred to adjudication. So this is obviously from the minority report, where the system predicts that Tom Cruise's character is going to commit a crime and it changes as a result. The point is here, don't jump the gun. Again, you need to look at your contract. If it contains provisions that may or may not be conditions precedent, you need to decide whether or not you have complied with them before you take the next step, or can you explain and justify why that precondition shouldn't apply? Next case, please. So AMEC, this was determining whether or not a dispute had crystallized, and it was held that the considerations had to include the word dispute given its normal meaning, that the responding party must not have admitted that it was responsible, i.e. there's a dispute, and the ways in which the responding party doesn't admit can be very, very wide. So that could be from all the way to outright rejection of the claim to merely just saying nothing. And in those situations, you have to also look at the length of time that a party has been silent and how many times has a party been chased. So this is from the film Goodfellas, where Joe Pesci basically says that he takes exception to something and there's an argument, and not surprisingly, the other party ends up dead. So again, you need to look at the factual matrix. And if you want to create a dispute and the other party is either not saying anything, then you need to keep pushing them, and you need to either evidence some objection from them, or that you've given them repeated opportunity to put forward a contra case. Okay, last one, please. So this was the notice of adjudication and how severe a breach of the scheme had to be in order for the notice to be invalid. And the scheme says that the notice must set out the address that has been specified in the contract. And here they didn't use the correct address. But the judge held that you must consider if the breach was severe enough to put the notice in reasonable doubt in the mind of the party receiving it, i.e., was the breach sufficient to cause that party to be unsure if the notice was actually addressed to them or not. And they said that the notice had not been invalidated, and that was because here the notice had been referred to throughout the address, that had been sent to had been used throughout the contract, and therefore it wasn't clear that by sending it to that address, the responding party wouldn't be aware of that notice provision. So again, and there's also some cases in relation to bonds per hour where there's issue of notices came in. This is from the film Life, where two people are wrongly convicted. And here the point is you must ensure that you're making a major error, if not making a major error, when drafting your notice. So thanks, Cameron. You can now go on to Giorgiana's slides. So what I would say is, just closing on those points, is adjudication is a relatively simple process, but as practitioners and as clients, we make it very difficult for ourselves by not complying with contracts. There's lots of pros and cons. I say, if you want more information, do ask. So, Giorgiana, over to you.
Thank you, Bill. Well, yeah. You said top tips in debunking. I would prefer to start the other way around with debunking misconceptions, if at all possible, in 20 minutes. I'll make sure I'll enlist help from my colleagues from Simon Fagan and Malif Mendes. You need to pay attention, guys, because I might resort to your knowledge and support. So for us, when we talk about dispute boards, we mainly refer to a contractual mechanism. When I will use the word adjudication, different from what Bill have said insofar, I will strictly refer to a dispute board adjudication role. So the one to give a decision into a given case. To define a DB, I would like to quote "And a Debt" from Nicholas Gould and Christina Lockwood's 2017, if I'm not wrong, paper that said a dispute board is an independent and impartial person or panel of 3 persons appointed by the parties to a contract to help the parties to avoid and resolve disagreements that may arise in the course of the contract as quickly and sensibly as possible. Well, this definition already gives us the 2 roles of the DBs, the prevention role and the resolution role. If we look at the prevention role or the avoidance role, we refer to the DB assisting the parties in managing or resolving contentious issues and contractual disagreement before they develop into a formal dispute. When we talk about the resolution role, we look at the DB who provides the parties with an independent decision on formal disputes, thus enabling the parties to resolve such matters at project level. Not all the dispute boards have a dual role. If we look at the FIDIC ad hoc DABs in the yellow and silver 99 edition, much as the UK adjudication procedure, if you want, they fulfill strictly a resolution role. In exchange, if we look at the FIDIC standing DABs as in red 99 or in the gold 2008, in the pink 2010, and of course in the 2017 edition, they all fulfill a dual role. When we looked at this webinar from the large group of misconceptions that float around about dispute boards, we settled on our eyes on very few. One of the most common ones being that sometimes the users see DBs only as an extra cost rather than a cost-effective management tool. Some users simply say that DBs do not add value. And what value do the parties expect from a dispute board? Well, primarily, the scope of the parties is to get what they wanted when they concluded the contract. And that requires the control of time, money, and quality of the services or works, whatever is the object of their contract. What does a dispute board brings to the table? Well, dispute board is a control management process that proactively assists parties in a project to avoid or, if necessary, resolve disputes in a timely and cost-effective manner. And we already said that. When we talk about prevention of disputes, we look at prevention of disputes particularly from the fact that parties are losing time and money arguing, including in going so far as the arbitration, or they simply lose time and money because of delays or poor quality of the rendered works of services. And a DB is there to help them minimize the project costs and delays. The dispute boards will often attend senior management meetings and they would often be held in conjunction with the dispute board meetings. Parties together, you need to make sure of that. Together, the parties may consult a DB and ask for an oral or even a written opinion when necessary at a very issue stage of an issue showing a manifestation or potential of transforming into a formal dispute. Some other users are saying that the DBs cost too much. If we look at some statistics, you would see that the DBs are relatively to the budget of a project, and we talk about a large project in general, they're pretty small. Generally, the figures that came up in our research were somewhere between 0.05% to 0.15% of the project's cost. In all cases, it has been found that the cost of a DB is definitely less than any other formal dispute resolution process. Dispute boards, as an advantage, is also the fact that they're relatively informal. They do not or should not involve external consultants or lawyer at that time, and they do use real-time information that's readily available to both the parties and the dispute boards. But then when the parties tend to transform the dispute boards into minute trials is their fault. So that's when they do become expensive and when they do not add value to the project. Comparison studies between non-DB projects and DB projects almost always manage to demonstrate that there are significantly fewer and smaller cost overruns and schedule delays, that there is a successful rate of prevention of most disputes, and there is a much lower cost of resolution for those disputes which simply cannot be avoided. So we'll say that if you know how to use a DB properly, and if you make proper use of that dispute board, that will make its cost worthy by materializing all the theoretical advantages that we have listed before: a healthy cash flow, fewer and smaller cost overruns, and schedule delays. Another misconception that is frequently met is that DBs impose their own concepts of fairness and equity. Well, if we look at the procedure of fairness, that requires for the parties to receive a proper opportunity to prepare and present their submissions and all relevant information to the DB, and also means that a party must be given the opportunity to answer submissions and informations that were put before a DB by the other party. When we talk about equity, and that's a subject that we could talk for hours and still have the whole matter still under the iceberg, at the bottom of the iceberg. But I come from a civil law background, so I will tend to interpret the equity more in a contractual context, like an objective element that gives the legal expression to the economic concept of the contractual balance. If we look from a common law point of view, I think I would quote here Alistair Hudson in Equity and Trust, who says that the equity mitigates the rigor of the common law so that the letter of the law is not applied in so strict a way that it may cause injustice in individual cases. If you also look at the DRBF manual, that it's expressly showing that it is fundamental that these dispute boards must not recommend a compromise settlement or make decisions according to what they believe would be acceptable or fair to both parties. Individual notions of fairness or equity have no place in the DB process. The DB findings must be in accordance with the facts and circumstances presented, contract documents, and applicable law and regulations. So if the decision is principally based on subjective factors such as fairness and equity rather than on facts and applicable law, then the decision could be unenforceable. So it is up to you to make the correct use of the concepts. Some other people are saying that the presence of a DB promotes claim. Well, if the DB presence promotes claim, then something is rotten in the state of Denmark, as Shakespeare put it. To have claims should not be a bad thing. A claim means, or it should mean at least, that a party considers itself entitled to a remedy under or in connection with the contract, and therefore it simply follows a contractual procedure. A proper use standing dispute board will act before the claim is formed, so before it is materialized. Therefore, the DB will be able to provide assistance and informally discuss and attempt to resolve any issue or disagreement that may have arisen in between the parties. It is also possible, provided that the parties agree with that DB, when the DB becomes aware of an issue or a disagreement, to invite the parties to make jointly such a request. If we go to another misconception that says that dispute boards members are biased or are not qualified. Well, here I'll simply put the whole responsibility for choosing proper qualified and not biased members on the parties, because first of all, it is the parties who need to understand that they are proposing dispute boards member, and they need to understand that those dispute board members are not there to act at any time as their advocate or their representative, and they should not and will not take their side during a dispute. So there is an absolute requirement for a DB member to be impartial and independent at all times, and that's found also in the DRBF manual strictly worded, and there's also in the FIDIC documents. The concepts of impartiality and independence are well established, I think, in most legal systems and jurisdictions. And if we look at the most common definitions, impartiality simply means having no direct involvement or interest and not favoring one person or side more than another. But don't forget that questions of impartiality and the perception of bias are often, if not always, subjective matters. Independence means free from any influence, control, or determination of another or others. Again, this one, it is based on objective facts and can be assessed from the information that the dispute board nominee disclosed to the parties. If you're not satisfied with the disclosure or you're not convinced of their impartiality or independence, you simply should give up to continue to nominate them or to further sustain their names. In addition to that, the DB members have an obligation to make sure that the parties understood and make their own assessment based on their disclosures of the assessment of impartiality and independence of the DB members. The relationship between the DB members and the parties must be based on at all times on open and full disclosure, and they have to continue at all times to be impartial and independent, not only before they're appointed, but through the whole process, through the whole duration of their term. In terms of their qualifications, we will say that in an ideal world, you'll choose those dispute board members which are experienced in a range of technical, contractual, and commercial matters that are relevant to your project. When you look at the criteria that you, based on which you would select your members, you would look at the type of work and risks involved in your project. You would look at their dispute resolution experience, even if they don't have it as a dispute member as such, but they could have experience as facilitator or as a mediator, or even an expert or an arbitrator. You also look at their experience in the relevant legal matters that affect or may affect the matter, in particular the interpretation of the contracts and of the technical specification. And one point that I think it's very important will be the prior training and experience as a DB member. If you check all the criteria on the list, then you should come together with a sound board that you could trust to see your issues solved in a proper contractual manner. DBs are unreliable and lack the formality of legal proceedings, is what other people are saying. Well, instead of looking at the formality as such, I think you should look at the DB more as to take from a dispute board the advantage of a casual procedure that allows the party to present their issue for a quick and efficient resolution. I'm not saying that there should be no rules or no procedure, but actually it is good to have the rules and procedure adaptable to what is agreed between the DB members and the parties, of course, but adaptable to the concrete situation to reflect the specific needs and circumstances of the project. And as a minimum, the recommended provisions to be included into a set of dispute boards rules or operating procedures, if you're not operating into a FIDIC contract or a FIDIC type contract, you would look at the general statement of purpose, to the project information that you're going to make available to the dispute members, to how the DB meetings and site visits are going to be organized. You would also touch on communications, and you'll specify the dispute avoidance procedure as well as the dispute resolution procedure. So one of the most common misconceptions, at least in Central Eastern Europe, and I found it quite often though in Middle East and Central Asia and Africa, would be that dispute decisions are not enforceable. Well, many contracts and dispute board specifications provide that a DB decision will be binding and enforceable unless or until modified or overturned by a higher authority, like an arbitration award or a court judgment. But this approach is common in international practice, and it is used in particular with FIDIC contracts, but it simply means that a DB decision with an award in favor of one party is required to be implemented immediately by the other party. And if at a later time, the arbitration court or a state court, the regular court will overturn the award, then the awarded amount must be repaid. It should not be a problem, but in practice, enforcement and implementation of interim binding decisions has been proven quite problematic. And we were talking earlier today about our experience in Central Eastern Europe with our colleagues from Georgia. And we discovered that we have quite a different approach to this issue, where in Romania or Bulgaria, for instance, there will be difficult to enforce an interim binding decision. There will be an easy way by settlement in Georgia. So different countries, different traditions, I guess. It is difficult to categorize the approaches to enforcement of a DB decision in different legal jurisdictions. Any enforcement attempt should be specific to the case and the jurisdiction. And I would say here that it must be guided by experienced legal counsel in that specific jurisdiction. The most problematic or the most common discussion about enforcement of a binding but not final DAB decision will always be for us an example relating to FIDIC contracts. Because if you're looking at the subclause 20.4, obtaining the DAB decision, the paragraph 4 provides that the decision shall be binding on both parties, who shall promptly give effect to it unless and until it shall be revised in an amicable settlement or an arbitral award as described below. So for us though, because it's a contractual provision, is written to produce an effect, then the losing party must execute the DAB decision promptly. That's the effect of the clause, of the obligation that you committed to in the contract, that you're going to execute the DAB decision. If you do not execute it, then you are in breach of contract. And this breach of contract, that was an obligation that was agreed by both parties, can be simply brought in front of an arbitrable tribunal, separately from the main object of the DAB decision. In that case, I guess, under the reserve of the applicable law, of course, at all times, the arbitral tribunal will issue an award to oblige the losing party to execute the DAB decision as its contractual obligation. The 2017 edition brings some changes in the 21.7, the failure to comply with the Aab decision provides that in the event that a party fails to comply with any decision of a DAAB board, whether binding or final and binding, then the other party may, without prejudice to any other rights it may have, refer the failure itself directly to arbitration. So this time, the arbitral tribunal shall have the power to enforce that decision almost automatically. Well, if you try to do a proper job, to respect your contract, to do your best when you select the dispute board members, you shouldn't have any of these, you shouldn't encounter any of these issues that have developed into these misconceptions. And that gets us to the top tips, if you want. And our top tips will be, in principle, avoid to do things, refrain from waiting until it's too late to appoint the DB. because an early involvement of the DB is extremely important when the primary objective is dispute avoidance. That setting it up at the beginning of the contract puts the DB in a good position to assist the parties in resolving areas of contractual ambiguity, inconsistency, requirements of performance, or even design standards. And an early appointment in the same time will be useless if it is not accompanied by a proper procedures. You need to have a possibility of having early and periodical meetings between the DB and the parties. You need at all times keep the DB in the loop and keep him updated by sending him the main correspondence between the parties, the monthly reports, and so on. A second one will be avoid not properly vetting DB members, and we discussed about that, the selection. Keep in mind that both technical and contractual legal aspects are important. So you want a balanced panel. You want each member complementing his or her expertise and the skill set of the others. Be diligent when you're selecting your dispute board members. Avoid imposing procedural obstacles to access the DB. Well, we said it is not enough to appoint early the dispute board or to have it solve your dispute. It is necessary to have the proper mechanism and procedure in place to allow a dispute board to do its job. And you need to have the parties to ask for opinions or recommendations before they need to get to the stage of asking for a decision. If you want, it's a Jerry Maguire situation, help me to help you sort of thing. The DB is there to support your early resolution. So take advantage of any open discussion and any advisory opinions to enhance the board benefits to the project. Avoid limiting dispute board members' fees, expenses, or even the area they are coming from, because you should be very careful when you decide the limits to fees or reimbursable expenses and the like, because any other aspects related to the dispute activity or their roles, because any unreasonable limit could spoil exactly what you wanted to obtain from that DB and the DB procedure. Remember that the cheapest procedure or the cheapest option is not always the best. Quality costs money if you want in a way. So yes, you could choose the cheapest fee, but that's not going to guarantee you the best quality dispute board member. Avoid imposing limits on dispute board jurisdictions. Well, the dispute board provisions should very clearly establish what is the accepted role and jurisdiction of the dispute board in a manner that would allow the dispute board to retain a flexible and efficient approach to both dispute avoidance and dispute resolution, because that is what you are after, dispute avoidance in particular. So when issues arise or the parties are already in a dispute, it is important that the DB has a strong and clear authority based on the trust that he could only build during the period that he is exercising his preventive role. So to have a strong authority to take a robust attitude towards both dispute avoidance and dispute resolution. In handling a dispute, the DB must be empowered to determine its own jurisdiction and establish its own procedure where there is the case. If we look at the FIDIC contracts, all FIDIC contracts include a model DB agreement that incorporates a set of conditions and a set of DB procedural rules. So the principal provisions for the DB members and the parties are the DB's general obligations under general conditions, clause 4, and the DB's powers under the procedural rule 8. If you also want to look at the remuneration, that's covered under the general condition, clause 6. I did make a comparison between the 99 procedural rule 8 and the 2017 Rule 5 powers of the DAB, but I guess that's best to put it on on the website afterwards, because it's quite a long way to go. To conclude, I would say be sure that you or the parties you are representing know and correctly understand what a dispute board is, how does it function, and what is their specific role and purpose. If you don't use it properly, it could just become a road full of pitfalls. If you're missing what is important, namely that is a project management tool intended to help the project to be completed in time and with minimum disruption, you may get more than what you bargained for. And I mean that in a negative way, a lengthier procedure taking its toll on the parties' relationships, more costs, more resources spent in other ways than in the benefit of the project. If you use them properly, they will provide you with reasoned and detailed findings. Those findings will be taken by experienced and independent experts that do understand your projects. They understand the facts of the dispute, and they will provide everybody with a merit-based process in which you could have the utmost confidence. Thank you. I think here I rest.
Very good, thank you. Well, if I may, Bill, I'd like to just hop in with an additional remark related to Giorgiana's comments about the member selection. So we referenced the DRBF's manual, which came out at the end of 2019, and we did start with a new recommendation for joint selection. So the common procedure that most people are familiar with is that the employer nominates a candidate, which the contractor approves. The contractor proposes a member, which the employer approves. But in the scenario of joint selection, there's a pool of approved candidates that they jointly select from. And it gets the parties away from referring to a board member as the contractor's candidate or the employer's candidate. And that's an important mind shift for the parties, I think. We've always said that the dispute board members need to be mutually agreed by the parties, but moving it into that slightly new method for selecting in a joint manner further reinforces that in everyone's minds. So I just wanted to share that with you all. It's something that we're seeing be used by projects around the world, but it is a shift. And so that's sort of a new development in dispute board practice.
And thanks very much, Anne. I think that's a very good point. Okay, so before I start the questions, what I would say is that what's one of the biggest advantages of dispute boards? One of the biggest advantages and the benefits is it shows that all us with the hat of idiot on, when we enter a project, you've actually engaged and you are genuinely trying to avoid disputes. Look, I'm delighted to fill my desk with joy if you have a dispute. So if you have a dispute and you want to instruct me, that's amazing. But actually, do you know what? So many disputes could be avoided. And the dispute board shows that the parties have actually considered at the outset a sensible approach to reduce their costly spend on that process. The flip side, as Giorgiana finished with, is engage in the process. You know, there's no point doing it half-heartedly or without thought. There are lots and lots of people on this webinar that are really experienced, that, you know, you don't need to go to me or to Anne or to Giorgiana. There's loads of other people that you can go and ask. But if you don't ask, if you don't do it with a degree of pre-planning and pre-thought, you will end up with, you know, what you've asked for. And the point is that might not be what you thought you were getting. It is a really, really beneficial process. I think it can save time and money. The fact that it's involved from the beginning, that you can adapt the process, that the selection process is more open, are huge factors in then determining how that your contract is to be effectively administered on the negativity side. So we
Just
will.
a second, Bill, if I can. I guess from a civil law perspective, one of the factors that might prevent people in taking full advantage of the prevention role would be the fact that we don't have the no prejudice concept. So for us, it is a fear, if you want, that whatever you disclose at the time you seek an opinion or an advice from the dispute board member, there is also somewhere at all times in the back of your mind, what if at a later stage that will turn against me? I'm trying now to help. I'm trying to be open to a solution. I'm negotiating. I'm proposing things. I'm not admitting to a guilt, but what if the other side would take it? So I guess that could be.
I think that actually applies. I think the reality is that applies everywhere.
Okay.
I've had a number of instances over the last year where we've put forward in cases arguments because you're putting forward an argument for your client, and we've had to sit down and say this is what we call in the UK a punt. So a punt. So it's you're having a go, and obviously you have to bear in mind that if it doesn't work, what's going to be the impact of all that information, documentation you put forward to support this position, if that's going to contradict a later position. And I think the reality is that there's issues about different privilege and disclosure, but the reality is that if you start playing fast and loose with your documentation and what you do and don't disclose and the truth, your fingers are going to be burned, whichever jurisdiction you're in. And much as they say, you come to equity with clean hands. If you go into a dispute with an ulterior motive or some clandestine element, you be careful. It can come back and bite you. We've been asked by I think it was Robert Gerard. So one for you, I think, Anne. What insurance would you recommend for members of a DB board? Or it might be good for Giorgiana. What insurance have you taken out? So what insurance?
I think the answer is basic general liability, but maybe Simon Fegan can take off his mute button and chime in. That may be something that's come up in DRBF training before, and Simon is one of our leaders in that space.
Well, thank you for saying that, Anne, because I haven't got an answer. We really don't deal with personal insurance to be taken out. And I think a great deal has to be read into the particular agreement that you're signing as a DB member. Beyond that, I really wouldn't like to be, I think we step back from advising members what to do on an individual basis.
Yeah, I think it's a personal choice. I haven't seen it required, which I think was the second part of his question. Are people required to have a certain?
Well, if you want from a Romanian at least, but from an EU point of view, it is not a recognized profession. Not being a recognized profession, with all the requirements, what kind of training do you need, what kind of mentoring do you need to get to the practice side, and if there is any barriers of entry. So it's a not regulated profession. Not being a regulated profession, you cannot take insurance specifically for it. For instance, I would increase at all times my professional insurance as a lawyer to provide for that specifically, but I cannot have a standalone separate policy. I've tried in the past, and that's the answer. There is no type of insurance you could get. It's not a recognized profession, at least in Europe, a continental.
No, and if you're acting as a solicitor on a DB board, you will need to ensure that your professional indemnity insurance includes reference to the fact that you sometimes sit as a tribunal. My experience is then your broker will ask for more detail. Most brokers haven't the faintest idea what you're then talking about. So how you determine tribunal, I leave up to you, but certainly I would put down on your professional insurance that you sometimes sit in a tribunal capacity. Keep it nice
Yes,
and
you
broad.
just have to notify them of the
Yeah.
contract, provide them with a copy of the contract and a full copy of the rules as well.
Okay, another question from me, just while you're all mulling over your incredible questions you're going to ask. Giorgiana, do you see a move towards more standing dispute boards, or do you think that ad hoc is still prevalent?
Anne, would you like to go first or shall I go?
Go for it.
Okay, well, at least at a declaratory level, we do see a move from the ad hoc towards the standing dispute boards. And I think part of it is the 2017 edition of the FIDIC books and the lots of advertising and publicizing of the agreements between, I think, 9 signatory banks, MDBs with FIDIC on agreement to use and recommend the use of 2017 edition with as little as possible modifications in terms of dispute board, which means standing dispute boards. So at this level, yes, we started to see, and now I guess mainly because of COVID situation in Central Eastern Europe, for instance, and I'm saying up to the Kazakhstan geographical border through the Ural Mountains, if you want, through the World Bank in the field of health infrastructure, they are starting to put out for tender 2017 red contract with the standing dispute boards in it, non-modified, not touched, at least what we've seen up to the proposal for tender documents. What is going to come out in the end, we don't know, but we've seen several contracts in the countries around here, and they all have the standing dispute board. So at least the intention is there. Whether it's going to function or it's just going to be, you know, a little spring like back in the with the 99 edition, when everybody was happy hearing about standing dispute boards and how good they could be for the project. If it's not detoured, and if you get the people to the users of those contracts, the employers and the contractor, to understand and to learn about the goods of the dispute boards and how to use them, yes, is going to happen. If not, I think in a year's time, the curve will go down again.
Giorgiana's a great attorney because she's giving you the cautious response there. Yes, but, right? I would just add on to it to say that since I don't carry that role, I'm a bit more optimistic. We are seeing so much support from some of the big players in this space. So Giorgiana talked about the FIDIC contracts really enforcing the avoidance component, even changing the name to DAAB instead of DAB. So they're having an institutional strengthening there. Similarly, the World Bank she referenced, you know, they've long been supporters of dispute boards, and we have this disconnect between requiring the use of a dispute board and then enforcing it actually being set up. But they're also rolling out new initiatives that strengthen the need for a standing board. As an example, they have a gender-based violence initiative, which is very important to them. And in order for the dispute board to be a player in that initiative, it has to be in place from the beginning. So the World Bank and the other development banks tend to follow their lead, will be on an institutional level strengthening the requirement for a standing board. Now, on the flip side, I would also maybe argue, Giorgiana, and you can tell me if I'm wrong, but I would argue that maybe there are users who come into using a dispute board for the first time as an ad hoc. They don't fully buy into the process. They want to test it out. So they say, well, everything's good for now. When we have a dispute, we'll test out this dispute board and see what we think. Depending on their experience, that may be the last time they use ad hoc. It may help them understand the process to the level that they say, gosh, for our next project, we've got to start standing from the beginning because we missed the dispute avoidance component. We missed the opportunity for the board members to understand the underlying facts. And so then when we actually did have to resolve a dispute, it took more time because they had to play catch up. So, you know, there may be that first trial of an ad hoc, but then the continuing usage moves more towards the standing. And so as more and more owners are embracing the process, that changes over time.
And before Giorgiana, you drop back in, because I want to make sure we get some views from others. A sort of tangential question. For those people who are, for those clients who are unsure about dispute board, who's experienced here, whether they've had to persuade a client or they've been a client or they've been the advisor, about the sort of the persuading the client that it's worth that retainer cost and taking some of the points that Anne and Giorgiana have mentioned. How many of you have actually experienced that problem of persuading a client of that benefit in real life, in your contract?
Someone mentioned it in the chat. You can put up your hands if you're on video, right?
So,
Hi,
Bill.
Hi, Bill.
Yeah.
I think I'm going to be in that position very, very shortly. The project I'm on at the moment, there was meant to be a DAB constituted at the start of the job. Unfortunately, they didn't get around to it for some unknown reason. But from my view, it's something that is of vital importance for the project. And I believe the contractor maybe will be looking towards constituting it or getting the board constituted to take disputes forward where there's been a notice of dissatisfaction. From my point of view,
does that contractor have prior experience, or?
Well, I'm from the client point of view. I'm assuming they do. They're quite a large international infrastructure contractor, without giving any names away, working in Bangladesh. And you know, for me, a dispute board is, I think, if it's there, it's vital. If they're on from the start of the job, they can not only provide you some guidance on disputes and resolving disputes, but they can intervene at an early stage. And maybe, for example, maybe there's a disagreement about the interpretation of the contract, for example. They can do an evaluation on that for the parties and move forward. And, you know, the ladies were saying there that, you know, it's a cost-effective method of managing a project management tool.
Yeah, and I think that's that, as you alluded to, the experience and managing, but then not constituting them at the right time, and the dangers that brings in sort of having to do it. Well, perhaps not after the proverbial stable door is closed, but so who's experienced problems? So who would like to share an anonymized problem that they've heard from a friend of a dispute board? The purpose being here to, you know, has anyone encountered a problem in the appointment phase, selection,
Bill,
anything like that?
there's a hand raised from Christian Groskopf.
Okay. Christian?
Well, if I can come in there after Liam's comments, is in the one project that we have in Pakistan, we've been trying to get a dispute board up and running now for 3 years. And there's just a neutral, well, there's actually no response from the client on that one. And the contractor is sensitive in trying to go to an appointing authority because he doesn't want to upset the client, which are creating a massive amount of animosity on the site between the contractor and the engineer because of very interesting views on certain contractual positions and terms. Now, this is ideal where a DB can come in, even in a advisory position. If there is a disagreement before it even is a dispute on should this be the case or should that be the case, Mr. DB, what do you think? And at least you know you're getting an answer which is not tainted by a preferred party. And so I can only suggest as the employer in your project there is, you push for it, get it in place. It can only help you enormously. I know of some other projects also where the DB was postponed and where people has gone into the appointing authority, and because of the time restraints, the outcome of the DB decision or the choice of DB members is currently being questioned or challenged after a very substantial award, DB award has been done by the DB. So I come back, Liam, is if you have got any control, any say in your situation, is get it in place. It is only going to help you in the longer run.
Yes.
I agree with that. I had two different experiences, if you want.
Totally agree.
The first time employer, first time user of a FIDIC contract with a standing DB in the water sector. And they were quite lucky in that they had a very experienced engineer who was mitigating at all times between the contractor and the employer and was trying to act in the interest of the project and was trying to explain to everybody the benefits of a dispute board and advise the parties on the selection of the dispute board members. So they were extremely lucky. They chose a board of 3 people that were exactly in the field that they needed to, was a particular expertise in that type of project, even if it was a combination of wastewater, marine discharge, water treatments, and all sorts. But they had a particular problem in there. And they were so lucky with the advice of a good, experienced engineer that they chosen a proper dispute board, and they've learned from that board through the project. And ever since, they were a fan of dispute board early adoption in the contract. In the same time, with a different authority, this time in the road sector, they were less lucky, if you want. They had a joint venture engineer who didn't send the best team. After the tender, they replaced the A team they were bidding with not even a B, but I think it was a rather D team. And they were having a very bad experience. They were advised not to appoint early, even if the contract was saying 28 days after the commencement. They didn't. When they employed in the end a dispute board, they went for the cheapest version, and they chose, and not only that was the cheapest, but was a non-experienced board member rather than the 3 as initially agreed. And they had a horrible experience, to the point that every single issue in that contract was distorted. And they've never again wanted to hear. It took about 6 or 7 years to get the team members of the public authority in that one to understand, to want to understand and look at other projects that were using them successfully. It was such a bad experience.
And so that also flags up a comment someone else has made about
Exactly. So it depends a lot of the people who you are using and who's advising you. So if you can get someone to help you get the best people in the business that you need.
So do you think you have to have a 3-party dispute board?
Not necessarily. I guess it depends on the project itself, or how complex the project is. Because if you have a small repetitive kind of job like a wastewater treatment plant that is nothing specific about it, I'm not saying that there couldn't be one, but one that it could be repeated around, then I guess a one-member DB could go ahead, for instance. But if you start looking into complex projects, combine, I don't know, tailings dams, water dams, and adduction, and bridges, and tunnels, and all sorts of others, I would suggest that you go for a more specialized, not necessarily 3, maybe even 5 people at a time. If you have a water facility in your nuclear plant, for instance, then you have to combine the projects and go to that. So if you look, for instance, to the World Bank recommendations, they say projects about $50 million US go for 3 members. Between 20 members, between 20 and $50 million, you could have either 1 or 3, depending on how complex the project is in particular. And if you are under 20 million US dollars, go for 1 member. But again, if that's a repetitive type of project, if it's not something specific.
And what's people's views about, again, it's been mentioned in the chat, what's people's views about the liability of, well, let's broaden it out, tribunal members. So as someone said, that might well be put on your gravestone. You don't sue a mediator. But what is the view where you are not, when you're in an alternative dispute process? Mm-hmm. So you're not using the inherent jurisdiction of a court of a particular country, but you have agreed on the appointment of a person or persons through an appointing body, and let's just exclude mediation. Do people think that you should be able to take action against members of a tribunal, and I'll accept that where there is fraud or dishonesty, we'd all say yes. But what's the general view? Do you think that if someone's just, let's say, incompetent, useless, biased, but you can't, do you think there should be liability? Who wants to have a go on that? A controversial view or not? None of you. So do you all think that they should be fully protected? No, Anil, you're shaking your head there, so you gave it away. So come on, tell us why you don't think they should be fully protected.
I think that, I mean, if you take on a role to make decisions like that, the points about your dishonesty and all of those things are things that you can never go down the path of. You should never have. I mean, last week I was in another webinar, and there was discussions about question about being impartial and all those things. But some of these things are things that are natural. If you're going to go mediate, if you're going to go arbitrate, if you're going to go adjudicate, you must know where the lines are drawn. You must know what good conduct is. You must appreciate what common sense is. I had an arbitration where I was a counsel for an arbitration matter, and the arbitrator was an architect. And at the end of the 3 days hearing, he said that there was an issue about how the air conditioning vent was measured, and he may have to consult and independent because both parties were giving different views, right? And he said may. Instead, what he does is that he makes a decision on 3 issues and gives a partial award, and then appoints an independent party to do the measurement and comes back to the parties. The parties were in the middle of making closing submissions. So we ended up taking him to task, taking him to court. And what the judge then did was this: the judge actually gave the notice to the parties, go tell the arbitrator, I want him to come to my court and explain to me what he did by Friday. And if he doesn't do that, pay back all the money. And the arbitrator paid back all the money. Now, if the arbitrator is going to say that the excuse was that he's an architect and he didn't know, all the points that I said was not just actually basic common sense. He should have known better. So, you know, your point about dishonesty and all those things, I think those are things that they shouldn't be allowed to be protected from, you know, if they make those decisions or take those angles going down. That's what I think.
Gerard, did you have a...
Hi, yeah, hi, good afternoon. I had a comment on the inclusion of standing DBs from the start of a project. I have some experience on MDB funded projects in Africa, mostly, whereby they're FIDIC forms, but both the general and particular conditions are quite heavily amended. And oftentimes the client or the employer, at the direction of their government, takes out the dispute board from the contract for 2 reasons. Occasionally the Attorney General or otherwise just doesn't like the process, and secondly, sometimes they find it expensive and they don't see the benefit of it. But inevitably what happens, I tend to find, is one of the earlier changes or one of the earlier variations really to put the DB board back into the contract when the project gets to site. So, you know, from my point of view, the system works. The dispute avoidance aspect of it is very, very important, and in my mind, the most useful aspect of it. So I think the DRBF and did a fantastic job of promoting the benefits of them, of dispute boards. That was my comment. Thank you for hosting the webinar.
Has anybody else got any comments?
I'd love to hear what Gerard said. I would just maybe say that when people take the clause out, it's clear that they don't really understand the process, right? Okay. To know dispute boards is to love them, right? But if you don't know them, then you're suspicious of them and you think, well, I don't need this. And it's only after things go sour that people realize that they need a better solution. And that's how the process was originally founded over 40 years ago. So
yeah, just if I could just follow on from George's point there. I done a lot of work in the Middle East, and they specifically cut out the DAB option in their FIDIC form, loosely based. And it's, as you say, it's a missed opportunity, and it's just a shame.
Yeah, it is.
Thanks for a good webinar.
It's going back to your first experience as well. So you don't know what it is, you don't know how to employ it. You had a bad first time experience. So if you're able to go over the first time experience, you'll discover, and willing to learn more about it in time, you'll discover the benefits. And yes, in Middle East and in Africa and in Eastern Europe, there is the tendency of crossing the DAB clause out altogether. Not only the standing one, but also the ad hoc one. But I've discovered in my past years of working with FIDIC that many authorities, once they find out, and there is, for instance, there is the Ministry of Public Procurement in Doha. There are ministries around Africa, in Zambia, in I think in Morocco as well, that were working with EU funds and had the chance, if you want, to have a good technical assistance component on their project. They had a good consulting engineer that taught them at the procurement stage why and what to do best and how to overcome the very first negative experiences. And now they're fans of dispute board process. And I know that because they were concluding licenses agreement with FIDIC to use FIDIC contracts with dispute boards in them. They had a particular, a set of particular conditions negotiated with FIDIC, including dispute boards. So I think steady state, it's slow and it's a needle in a haystack.
There
but
are
it is
also,
a part.
yeah, there are also poor advisors who I think sometimes see DABs as removing work. So, you know, I'm a solicitor, and they see it as removing work. Well, actually, there's still plenty of work to do if there's a DAB, and it is a mistake, and it's actually it in fact demonstrates that you're not acting in your client's overall interest, because the client's overall interest is, you know, if there's going to be a massive dispute, that massive dispute will happen anyway, but it will probably be a more containable and definable dispute because of the proper operation of the DAB. Okay, so I'm conscious that it's 20 to 1. Obviously, there are a lot of people on here, and it's an opportunity. Does anybody have any blinding questions they'd like to ask anybody else on the call whilst they are captive? Obviously, you know, not necessarily me, but if there's someone else on the call that you scroll through and you think, oh, I'd like to ask that person a question.
My question is to Anne. We always talk about the savings that we make by going to DBs when looking at claims that surface during the construction period. Do you have any information about how much money clients have saved in avoiding disputes on projects? Because the disputes that have been avoided are not measurable. Nobody measures what claims and disputes we have avoided at the beginning. Have you worked on any way to have people have lessons learned and estimation of how much was avoided, rather than how much we paid versus how much we would have paid in court or in arbitration?
Well, it's an excellent point, and I agree with you that the emphasis needs to be on those stronger benefits, not just what did it cost you, but what did you save. And you know, you hit the nail on the head that it is not really possible to run two projects, exact same conditions, one with the board and one without, and have a definitive answer on what those tangible savings were by having the dispute board in place. So there is a bit of faith that needs to go into it. But also, you know, people who are experienced in these complex projects and know that problems are going to occur have been through very lengthy and protracted resolution, whether it's arbitration or litigation, know in their bones that the savings are substantial. So there's no, you know, hard number that we can put to it other than, as you said, to share lessons learned. And we have done some surveying of dispute board users and tried to put together some useful guidance with facts and figures that help make the case. We certainly have impassioned people who talk about the problems that they faced on a project and what could have happened if it had not been resolved. So we have those in an anecdotal way. We have them in a statistical way, although there are, you know, constraints to the statistics, the ones that we've already noted here. But that is a common question, a common issue that people are looking for in making the case for dispute boards. I recently wrote an article on the case for dispute boards for Bill's, for Barton Legal's newsletter, and you might reference it. It does talk about framing the use of a dispute board in the context of insurance for your project. People are very comfortable, you know, knowing that they need insurance for a major project. And if you think about those hard costs that you have as being an investment in dispute avoidance and resolution over the duration of the project, then those numbers make a lot more sense.
I seem to help you. I would say that in the absence of clear figures, go and ask solicitors, lawyers who are dealing with large projects, and ask them, you know, you'd have to be anonymous, would they rather have a dispute from, major projects, say 50 million, would they rather have that just come to them as some sort of big dispute, or would they rather have had the DAB involved? And I think they'd all say, well, if there's been a DAB, the number of disputes that are going to come to me as a lawyer will be lessened, because things will have been chipped away during the course of the project, and what actually ends up arriving on my desk will be a bit smaller. So if you give me the optimum, it will be the whole lot. And I know it's a reverse and taking Peter point, proving a negative, but actually that's as good a way as saying to a client as any. Would you rather spend loads and loads and loads on your lawyers, or would you rather try and avoid that by chipping away at the disputes? And if a real dispute pervades through that, that will still go through, but that's an alternative way. Does anyone else have any other brilliant, burning questions, or even just something mundane? Because otherwise, we'll call it a day, because I'm conscious that, you know, you all perhaps have things to do. I know Anne's in the morning, and lunchtime here is different times, even in Scotland. And I'm not sure if...
It's been great to be a part of this webinar today and to hear such engaged conversation and experiences from the other attendees as well as the panelists. So thank you for putting this together.
Well, I hope people all enjoyed it. And just before you dash off, can you please mark your diaries for the 25th of March, 11 o'clock, where the inimitable Gordon Nardell, QC, from 20 Essex Chambers, and Sue Kim from HKA will be talking about, and the title is The Long View, What Parties to Long-Term Project Contracts Need to Know About Disputes and Avoiding Them. So again, this is all part of our helping everybody to collaborate, come with experience, and Gordon has lots of experience of advising clients on a host of large multi-party, also through World Bank and other funded projects. So that's the 25th of March, 11 o'clock. If you want any of the material from today, you'll get an email. You can then go to the website, download the material. You'll be able to download the edited highlights recording of today, if that's of help. Please do, it would be great from our point of view, please do put comments in LinkedIn if you've enjoyed the webinar. We do try and reach as many people as possible, and the aim is to be as collaborative and sharing as possible. This isn't, you know, just about us. I'm really passionate about people sharing experience and trying to help us all learn from things. Obviously, if you've got a dispute and you'd like to send it to me, then that's fine as well. Otherwise, I'd really like to thank Anne and Giorgiana for the huge amount of time and effort they've put in to making it so informative. And I really do urge you, when you download the DRBF book, there's a lot of information. If either of you want to ask Anne or Giorgiana more questions, I can facilitate an introduction if you don't already have the details. But DRBF also puts on a range of other webinars, so do go to their website. They're really informative and very interactive. Thank you everyone for making the effort to attend today, and see you all again soon. Okay.